Freedom has many difficulties, and democracy is not perfect. But we have never had to put a wall up to keep our people in.
Backsliding Democracies, the Role of the Judiciary. The webinar and podcast series presented to you by Volunteer Jurist, Justice for the Rule of Law, and the Swiss Institute for the Judiciary.
Ladies and gentlemen, welcome to our webinar, The Path to Authoritarianism, Backsliding Democracies, and the Role of the Institutions. This event is part of the initiative Backsliding Democracies, the Role of the Judiciary, organized by three institutions: Volunteer Jurists, Justice for the Rule of Law, and the Swiss Institute for the Judiciary, which I had the privilege to initiate. The two first associations were founded by judges, prosecutors, and lawyers who fled Turkey following the 2016 coup attempt, persecuted simply for defending judicial independence and the separation of powers. Many of us involved in this project know these issues not only from theory, but from personal experience. My own engagement goes back many years, driven by concern that threats to an independent justice and the rule of law are no longer isolated or theoretical, but global and immediate. Let me introduce the three guests of our webinar today: Professor Margaret Satterthwaite, Professor Petra Barth, and Professor Laurent Pech. Welcome, everybody. Professor Margaret Satterthwaite is an international human rights scholar and practitioner with decades of experience in the field. She is a professor of clinical law at the New York University School of Law, where she directs the Global Justice Clinic and serves as a faculty director of the Robert and Helen Bernstein Institute for Human Rights and the Center for Human Rights and Global Justice. And she is the UN Special Rapporteur on the independence of judges and lawyers. Professor Petra Barth is Professor of the Sustainable Rule of Law at Radboud University Research Center for State and Law in Nijmegen, Associate Professor at Eötvös Loránd University Faculty of Law Budapest, and research affiliate at CEU Democracy Institute Budapest. Professor Laurent Pech is full professor of law, dean of law, and head of the Sutherland School of Law. He is also a visiting professor of law at Bordeaux University, a senior research fellow at the CEU Democracy Institute in Budapest, and the co-director of the Good Lobby Profs, which he co-founded in 2021. I am very pleased to have you here today as my guests, three distinguished specialists on the topic we wish to discuss. It's a great pleasure to have you with us. What can you expect today? We will begin with three keynote presentations from our distinguished guests, each offering a unique angle on institutional backsliding. This will be followed by a moderated panel discussion in which we will explore what exactly do we mean by backsliding democracies and authoritarianism, what drives these developments, and what can be done legally, politically, and institutionally to counter them. But before I hand over to the first speaker, let me make a few introductory remarks. Why does our debate matter? What unites us all, organizers, speakers, and webinar participants, is a shared commitment to judicial independence, the rule of law, and the separation of powers. But this webinar is not meant to celebrate ourselves for having the right attitude and reaffirming to each other that we are doing the right thing. It is also an invitation to critical reflection. Let me briefly share a personal perspective to explain my point. For over 40 years, I have advocated for judicial independence nationally and internationally. Yet only in the past 15 years, through my work at the Swiss Federal Supreme Court, have I fully realized that the judiciary itself can sometimes undermine institutional balance. This happens when courts act politically without mandate, overreach into legislative or executive domains, or ground their legitimacy more in outcomes than in method. Let me make a personal example. I myself have at times welcomed judgments by the ECTHR fostering judicial independence, whose reasoning, in hindsight, lacked a solid treaty basis, relying instead on soft law or teleological interpretation. My positive reception of this case law at this time was very results-oriented. Today, I have doubts if the result justifies the means, or whether it is not rather of decisive importance that courts proceed methodically correct and remain within the limits of their jurisdiction. Why this remark? There is a tendency in current discourse to treat all elements of liberal democracy as an absolute good, to welcome any steps forward, regardless of who takes them, and to condemn any deviation from this noble goal as backsliding or autocracy. But could it be that some so-called backsliding reflects popular frustration with elite-driven institutional expansion? Scholars like Philip Manoff have suggested that supranational courts, political actors, or constitutional courts and technocratic elites may have overstepped, provoking a legitimate reassertion of democratic sovereignty. In our last podcast, Wim Woermans called these reflections simplistic. He said that the whole idea of a liberal democracy is that it's a limited democracy. But isn't that itself an overly hasty dismissal of legitimate questions? Hasn't the bow really been overstretched in recent decades by one-sided developments driven by political elites with the help of the courts? Bruno Frey and Oliver Zimmer speak of an epistocratic, sometimes elitist understanding of politics, and Manoff calls it constitutionalization of democracy and delegation of political decisions to non-majority institutions. If you admit that these observations cannot simply be brushed away and get over it, isn't the reaction of the people to this not only understandable, but also at least partially, and maybe only partially, legitimate? So the key tension we explore today is this: where do we draw the line between justified democratic correction and authoritarian regression? And are we willing to apply this scrutiny also to the very institutions designed to protect democracy? In this sense, I am hoping for a discussion that remains open, honest, and self-critical, even when that means challenging our own assumptions, and also to critically examine the behavior of important actors. Because only through such dialogue can we begin to rebuild trust, prevent polarization, and defend democratic constitutionalism in a credible way. With this introductory remarks, I'm handing over to our first speaker, Professor Petra Barth. Professor Barth, you have the floor.
Thank you so much for this utterly kind invitation and introduction. And now I will ask for some technical help. I hope my slides are shared already. Wonderful, thank you so much. So there are plenty of things I wanted to share with you today, so I will jump right into the structure of my presentation. I would first like to talk a little about the rule of law decline in the European Union, then delve into the autocrats' playbook that they typically use irrespective of jurisdiction with a special regard to judicial capture. Then I will look into the scope and limits of courts fighting for judicial independence. How far can they go? What is the line that they mustn't be crossed? I will look into the reasons for judicial deference at times, especially on the side of the Court of Justice of the European Union. Then I will look into illiberal techniques of capturing courts via legal cheating and derive my conclusions. So the rule of law has a special role for the European project, advancing a clear idea of constitutionalism taming nationalism by reducing the risk of another European war and diffusing the model of liberal democracy to countries with an authoritarian past. Now, when I say European project, I have both the European Convention on Human Rights in mind and the case law of the ECHR, of course, and already since Golder versus the United Kingdom, the rule of law belongs to the Council of Europe's common spiritual heritage. But I also have the EU in mind. Let me now just borrow from the words of Ken Leonard's president of the Court of Justice of the European Union, who said integration through the rule of law defines what the European Union today stands for. Now, there is also a legal underpinning for these words, not just Article 2 laying down the values of European integration, but also Article 3 of the Treaty on the European Union, according to which states must promote these values. Furthermore, in line with the principle of sincere cooperation incorporated in Article 4.3, the member states must not hinder, but ought to assist EU institutions when promoting Article 2 values, including the rule of law, fundamental rights, and democracy. Now, despite these treaty obligations, values such as democracy and the rule of law and fundamental rights are violated in several member states. The European Union even harbors countries where systemic violations of the rule of law, including judicial capture, are part of the system of governance. Now on the slide, you will see the decline based on the data from the World Justice Project. I could have selected other think tanks showing the same decline, including the Bertelsmann Stiftung, Freedom House, and many others. It's the same trend that can be seen from a methodological perspective. I selected Poland and Hungary to show you the decline in some parts of the members of the European Union, just because these are the two member states against which Article 7.1 proceedings have been started. These are the only two member states against which such proceedings have been started for value violations in the history of European integration. Now, of course, every member state has some rule of law issues. One can criticize the structure of the judiciary in every single member state, but in systems which tend to go towards authoritarianism, which we tend to call hybrid regimes in the literature. Elected public authorities deliberately implement governmental blueprints which aim to systematically weaken, annihilate, or capture internal checks on power, with the view of dismantling liberal democracy and entrenching the long-term rule of the dominant party. This was a quote from Professor Pesch and Professor Shapley. So this is not a bug, but a feature that the rule of law decline is happening via, by the way, constitutional entrenchment and the adoption of certain laws. So there is also a veneer of legality to rule of law decline as it is happening. So one would, because of the importance of courts for the whole European project, because ultimately this is the Court of Justice of the European Union that interprets European Union law, but ultimately it's the national courts that must apply it. One would think that the European institutions actually step up persuasively against rule of law decline. But as we have seen, unfortunately, these steps have not been dissuasive enough, whether we are thinking of Article 7 proceedings, infringement proceedings, or conditionality proceedings, but I'm sure Professor Pesch will talk more about this. So now I'm here to show you how this decline in some parts of Europe is actually happening. I base my five-step approach on Levitsky and Ziblatt's theory on how democracies die, which we have reworked with Professor Pesch long ago, some 6 years ago already. And I reworked it further for the sake of this presentation. So the first step is always a loss of trust by the population. There's a crisis in the party system, and the electorate votes for the party that promises a sea change. Now, once this party is elected in a free and fair proceeding, and let's remember that it is free and fair because for a long time this will be the last election that is still fair. As a step number two, the new government will capture state institutions, undo checks and balances that are system relevant, and court capture happens right at the beginning of capturing state institutions, especially the capture of apex courts. Because whatever laws or even constitutional amendments a new government adopts or a new parliament adopts, they could be questioned by a constitutional court or Supreme Court. So it's of vital interest for illiberal regimes to capture courts first. Then they go in the direction of populism, scapegoating traditionally discriminated minorities such as the LGBTI community, migrants, but also new enemies are invented, such as people turning to Luxembourg court or to the Strasbourg court have been scapegoated in the past. Then there is manipulation of voter preferences, especially via media capture and distorted election laws. So it becomes increasingly difficult to vote out the government. And finally, in the EU context, there is abuse of law as a response to European criticism, so that European dictates, including Court of Justice judgments, do not have to comply with. Now, how does court capture eventually happen? Again, just using the same methodology, thought about just having some highlights from Hungary and Poland. So in Hungary, the Hungarian Constitutional Court's authority and its independence was undermined right at the beginning after Fidesz won a parliamentary supermajority in 2010. They expanded the bench from 11 to 15 and extended their tenure to 12 years, thereafter appointing only closely allied judges to shift the court's ideological balance. Then it's not only that they gave more room for loyal judges, but they also cut back the powers in general of the Constitutional Court to be on the safe side, so they couldn't rule on budgetary and financial matters. Previous Hungarian Constitutional Court rulings have been repealed by law, by actual constitutional amendment. Provisions once declared unconstitutional by the Hungarian Constitutional Court were reincorporated into the new constitution, so that because in Hungary there is no unconstitutional constitutional amendment, the Hungarian Constitutional Court just couldn't declare these laws unconstitutional again. Ad hominem laws were used to oust critics, such as the Supreme Court President, András Vaka. The European Court of Human Rights found this violated his right to a fair trial and freedom of expression. And also tailor-made laws were then used to ease procedural hurdles to appoint another candidate for the Supreme Court presidency, Judge Varga, who didn't satisfy the requirements, but two laws have been adopted so that he can be landed as Supreme Court president. The control over the judiciary has been centralized in the hands of the National Office for the Judiciary, and entirely politically appointed president had the power to hire, fire, discipline judges, to assign cases, and so on and so forth. Also weakening the self-governing body of the judiciary, which was called the National Council of the Judiciary. Fidesz government unilaterally and with immediate effect reduced the age retirement of judges, prosecutors, and notaries from one day to another, from 70 to 62, thereby getting rid of the most experienced judges and court presidents and filling their positions with party loyalists. The government has actively pursued judges willing to act according to professional standards, including in politically sensitive cases. They went after them with disciplinary proceedings and suspending them as judges. The Fidesz parliament persistent disregard for binding judgments further threatened separation of powers. Examples include failing to pay compensation to Roma victims of school segregation and prisoners held in inhuman conditions. Now, in Poland, the situation has been somewhat different because Poland didn't have a constitution amending or making majority in parliament, so they tried to change the system through the back doors. First, invalidating 5 judicial appointments made by the outgoing Sejm, which wasn't entirely regular either, or at least 2 of them. But then they appointed their loyalist judges, leading to actually double appointments. The Constitutional Tribunal became politically captured right at the beginning, so it stopped reviewing key government legislation and declared unconstitutional the previous Sejm's judicial appointments. The government simply refused to publish the rulings of the Constitutional Tribunal it didn't like, as if they never existed. Then they introduced the National Council of the Judiciary. Members were elected by the parliament rather than judges, ending judicial self-governance. They had a new law on the Supreme Court and a law on common courts, giving the Minister of Justice broad powers to appoint and dismiss court presidents. They adopted a very similar law to the Hungarian one on forced retirement, but here the Court of Justice already responded in a more meaningful way, and at least some judges could be reinstated. They established a disciplinary chamber, which started disciplinary proceedings against judges who applied EU law, questioned the independence of or judges who questioned the independence of the disciplinary chamber or the legitimacy of the new appointees had to undergo disciplinary proceedings too. They passed the Mazl law, according to which judges couldn't question the legality of judicial appointments, and they were also sanctioned for applying Court of Justice rulings that undermined so-called judicial reforms. Ultimately, the Court of Justice held that the disciplinary chamber is not independent, and Poland was required to suspend its operations. As a response, the Polish Constitutional Tribunal simply said that they just do not follow anymore the principle of primacy of European Union law. And this whole conundrum stopped in 2023 when the Peace Party lost the elections, and now the new government, or not so new government anymore, is preoccupied with restoring judicial independence, which is a much more complex issue than we all hope to be. Now, I will just say that the courts have been fighting for judicial independence, and the Court of Justice has a very much forward-looking case law since the Portuguese Judges Association case. The Court of Justice of the European Union declared what an independent court means, how judges are to be appointed, dismissed, retired, remunerated, and I'm sure Laurent will talk a lot about this. But I would like to point to a different case law in the area of mutual trust and mutual recognition. And this is very visible in extradition cases or surrender cases, where the question was whether it's a good idea to surrender people from democracies where they are not likely to have a fair trial by an independent judiciary because the judiciary is not independent anymore. And here I reproduce on the slide the leading cases. And I just draw your attention to the LM case where the court just repeated a previous test that it developed in relation to prison standards. And it held that in such cases, first, the executing court has to determine whether there is a generic problem in the country with regard to judicial independence. And second, it has to show how the individual would be affected. Many of us have warned against this test, saying that the second prong of the test is almost impossible to satisfy. And indeed, in a research project called STREAM, we haven't found any cases that have been stopped on the basis of this two-prong test. But the Court of Justice still insists on not declaring a whole judiciary not independent. There are many reasons that the court invokes. You know, there's a fear of impunity, respect for victims' rights, and the main reason probably is deference. So the court just doesn't want to say that a whole judiciary, a whole national judiciary is not independent. But it also has a reason, which I circled here on the slide, which says that even in a very captured state, there are some judges who are independent, and the executing judge should check whether, for example, if you surrender someone from Germany or the Netherlands to Poland or Hungary, then the surrendering judge should just check whether the Hungarian or the Polish judge is going to be independent. Now, I applied a theory by Ernst Fraenkel to this test developed by the court, showing that in a captured state, no judge can be safe and no judge can be truly independent. Fraenkel, of course, has a very specific theory in a very specific period of time in the 1930s Germany, where he said that there are two parallel legal systems. The one is the normative state, which is kind of the normal rules of the day. And there is the prerogative state, which is defined by arbitrary rule. But he shows that since it's the prerogative state, so the arbitrary state that has the power of competence, the power to determine jurisdiction, no procedure could function along the rule of law. So this is very true not only for fully fledged dictatorship, but also for hybrid regimes where case allocation is a varying topic. So case allocation is usually dedicated to people who are actually direct appointees of the government. So as Fraenkel himself puts it, the normative state is only ever as strong as a prerogative state allows, and that allowance is both undefined and unstable. So no person, no judge in a state capture can be independent. Now I will move to techniques of illiberal governments questioning judicial independence. And of course, it doesn't happen directly. So there is no state in Europe that would say that they would be against judicial independence or against the rule of law. Everything happens in a hidden way, or as András Sajó puts it, in a form of legal cheating. So sometimes they pretend to be compliant with the rule of law, but they are not. So my favorite example is when the new Hungarian constitution was adopted and the government knew that it's not EU law compliant, and they sent a different English version to Brussels than the actual Hungarian text. Other times they pretend that they are complying with a certain law or with a certain judgment, but it's just paper implementation, cosmetic compliance. Otherwise, it doesn't really adhere to the judgment. Now, unfortunately, captured courts can also help the government by hijacking principles such as sovereignty or constitutional identity, which are existing and legitimate theories, but they are in these illiberal regimes are just there to rubber stamp the government's or the parliament's departure from European Union law. They also invoke fake international examples or best or worst practices from across the world, the most rights-infringing practices, or taking legal constructs from other jurisdictions, taking them out of context, and then saying that there is an international example for whatever the illiberal regime has adopted. Another argument, seemingly intellectual argument, is the argument of judicial activism, the creation of a juristocracy. And this is happening by fake academics, or I'm not here to tell that, but so by people who are hijacking theories like the dual state theory. So for example, in Hungary, we have a former constitutional court judge from the captured court who developed his own idea of the dual state. He warns of a juristocratic state where, alongside the sidelining of democracy, the power dominance of constitutional courts and the judiciary is emerging. His understanding of the dual state is the following. Central and Eastern Europe exhibits a dual structure, in his view, composed of democratic and juristocratic elements. The democratic element is what the government of the day adopts, or the parliament of the day adopts in the form of laws. And the juristocratic element, the prerogative state, is a foreign elite project which from the late 1940s aimed to bring about the plan of certain Western European elites for the creation of a United States of Europe. This prerogative state is upheld by judges, NGOs, and academics. So he delegitimizes courts as being out of control and thus laying intellectual groundwork for judicial capture. This is a typical topos, often applied by autocrats. The prerogative state is supposed to be truly democratic, as it follows the will of the majority, and everyone else, the courts, academics, NGOs, are just part of the prerogative state. Now, this has been dismissed for a very long time as some unserious theory, but unfortunately, it currently has practical relevance. Just a couple of months ago, a government decree in Hungary has been adopted on the provision of the resources necessary for the implementation of a priority task. What is this priority task? It is the attack against the Court of Justice of the European Union because it passed a judgment holding Hungary to be responsible for disrespecting asylum laws of the European Union. And because Hungary didn't comply with the judgment, Hungary will take the Court of Justice to court, challenging the 200,000 euro lump sum payment and the daily 1 million payment against Hungary. Interestingly, Hungary doesn't attack the original judgment, it just questions the legitimacy of the court to enforce its original judgment. So unlike the vice judgment or other judgments, actually the Hungarian government questions the whole construct, the whole European construct with the Court of Justice of the European Union enforcing European Union law. So in conclusion, let me say that in my view, what is truly dangerous is not that courts engage with values. They actually do that all the time. But that they cease to ground their reasoning in law and instead become instruments of political will. That's the line that must not be crossed. And it's crossed not by any court that renders decisions that we disagree with, it happens all the time, but by those that abandon legal method altogether. The real locus of concern lies not in courts implementing law differently, but in whether they abandon lawful methodology and openly serve political agendas. Thank you very much.
Thank you very much, Professor Barth, for this very interesting thoughts you shared with us. And we're going directly on to Professor Pesch. You have the floor, Professor Pesch.
Thank you very much. I'm going to attempt to share my slides. And I'm going to play them. Okay, so play from the start. And hopefully you can see my slides now. And essentially, I'm going to build on Petra's presentation. I'm going to look at the responses or the non-responses from the EU in relation to democratic and rule of law backsliding in the EU. I'm going to also tell you a bit more about the case law of the Court of Justice in this respect. And I will also include some references to the case law of the European Court of Human Rights. And I will conclude with actually one of the judgments mentioned by Petra, the one essentially finding against Hungary for disregarding previous judgments of the Court of Justice. So hopefully I will complement very well what Petra has said. But before I get to the application or non-application of the EU's rule of law toolbox, I'm just going to give you also kind of a transversal overview of the situation in the EU, and I'm afraid it is quite dire from both a democracy and a rule of law point of view. What we're talking about today was not talked about in the EU before 2012-2013, when the expression rule of law crisis slowly emerged. The last time we amended the treaty rulebook governing the EU. That was before the expression rule of law crisis began. And that was with the Lisbon Treaty. The Treaty of Lisbon did make a number of changes to the EU primary law framework, but was not adjusted in light of what is now described as rule of law backsliding. So this is why, to a large extent, and that is a transversal point, the EU has been playing a kind of a catch-up game in the absence of a treaty framework which was specifically designed or adjusted to deal with what has been known as the rule of law crisis. It took about close to 10 years before essentially the situation got so out of hands that both presidents of the two European supranational courts publicly stated something they would not have stated a few years back, that essentially both the EU and the Council of Europe are facing, if you don't mind me putting it that way, an existential threat. So it's not simply an existential threat for the EU legal order, it's also an existential threat for the Council of Europe, whose membership is technically based on compliance with three basic principles designed and devised or put forward after World War II, essentially respect for democracy, the rule of law, and human rights. Here you can see on the slide that President Leynaerts actually spoke of the very survival of the EU project in its current form being at stake. This is very strongly worded, very unusual for a sitting president to be so explicit. And he did so in a context where I think it's fair to say the Court of Justice was not overly impressed with the responses of the EU political institution in respect of the so-called rule of law crisis, which was first identified, as I said, by the Commission under President Barroso in 2012-2013. I think it's also worth noting that rule of law backsliding has also been mentioned by successive presidents of the Strasbourg Court. Here, I'm just sharing a quote from a speech by former ECHR President Shifra O'Leary in 2023. And she does mention, as you can see, rule of law backsliding, but also she does emphasize the idea of democratic regression in previously stable democracies. So what we can conclude from this slide is that both courts are fully aware of the existential threat they are both facing in terms of what has been described as rule of law crisis. I know that Meg is going to tell us about the global dimension, so I'm just going to be brief. The rule of law crisis now unfolding, continuing to unfold in the EU, is part of a global phenomenon. And in fact, this is essentially from the last edition of the Rule of Law Index, an annual rule of law report assessing a country's compliance with the rule of law as understood by this organization. And I think they used a very apt expression of a global rule of law recession. And this global rule of law recession is affecting a large number of EU member states, but you will see that the depth and the intensity of this global rule of law recession has impacted countries quite differently. But I'm going to focus on the EU only. And this is essentially, I have highlighted the situation of Hungary as per the data you can extract from the rule of law index. On the left side of the slide, you can see the biggest rule of law declines for the past 12 months. And you can see one EU member state which is mentioned in this list, and Romania. So I'm just going to park aside the situation in Romania for now, but I'll get back to Romania in a few minutes. So in the top 10, you see one EU member state. You can say, well, happy days, only one EU member state out of 10. Then the situation cannot be that bad from a rule of law backsliding point of view. You would be wrong to think so. Something very important to keep in mind is that these annual reports tend to look at the situation on an annual basis. So if you have a very poor rule of law record and you suddenly slightly improve, then you're going to be seen as no longer declining. It doesn't mean that the situation from a rule of law point of view has dramatically improved. So what is important to always bear in mind is the overall evolution or the pattern over many years. And then if you look beyond 12 months, and if you, let's say, take a 10-year horizon, you can see that essentially, that's why I picked Hungary. This is the worst backsliding EU member state, taking 2015 as a starting point, at least from the point of view of this rule of law index. Not all the rule of law benchmarks used in the World Justice Project can help you detect autocratization or backsliding. I think what you need to pay attention to is what they call factor one, constraints on government powers. This is the key factor one needs to pay attention to when you want to be able to detect a pattern of backsliding or not. And here you can see that since 2015, obviously, the pattern is quite clear, so much so that you will see that I'm about to make that clear. Hungary essentially is no longer considered a liberal democracy, not even an electoral democracy, but an autocratic regime at this stage. And this is where I'm connecting rule of law backsliding and democratic backsliding by mentioning now some of the findings you can find or can extract from another annual report, but this time about democracy. And this is the annual report published by the Swedish research institute known as the VDEM for Varieties of Democracy. They publish a very helpful annual overview of democratization versus autocratization worldwide. And they distinguish between different categories. As you can see, you can have two patterns, either a pattern of democratization or a pattern of autocratization. Autocratization may be understood as synonymous with backsliding, or at least that's how I would understand it. And so in the case of backsliding, what we're talking about is essentially in the case of some EU member states, some EU member states have essentially follow a pattern, an autocratization pattern, leading quite a few liberal democracy into becoming electoral democracies. But Hungary is by far the worst case of backsliding in the past 10 years. So much so that, in fact, according to this annual democracy report, Hungary should be understood now as an electoral autocracy. So meaning essentially you still have elections on a regular basis, but these elections are structurally rigged, to put it simply, in favor of the incumbent. So you have some elections, but they are no longer structurally free nor fair. And in addition, essentially, obviously, judicial independence has been systematically undermined, so much so that the ruling party in Hungary can control every judicial outcome in every case deemed important from the point of view of the ruling party. Petra has explained the mechanics of capturing the system, but essentially they have made sure that at the end of the day, they can essentially select the right judge for the right case to guarantee the right outcome. It'll take a bit too much time to really explain the mechanics more than this, but essentially the important point at this stage is to understand that at least one EU member state is no longer a democracy at all. This is not simply my assessment, this is the assessment of this Democracy Institute, and an assessment which has been adopted by the European Parliament in a resolution adopted in September 2022. So I told you about Hungary. Essentially, if you look beyond Hungary, you can see also an additional number of EU member states mentioned in the annual democracy report last year, or in the latest edition. The report highlighted the situation in Greece and Romania. So we have more than one backsliding country in the EU. At some point, once you have backslided so much for so long, then in fact, there is no room for any further backsliding. Then you can have stagnation. But again, it doesn't mean that the situation has improved. It's essentially, it means simply that autocracy has consolidated, and to a very large extent, this is arguably the situation in Hungary, even though there is forthcoming elections, and we shall see whether, in fact, the opposition, which is now leading in the polls, will have a chance to actually win the elections, notwithstanding the fact that the electoral playing field has been structurally rigged to the benefit of the incumbent. In addition to Hungary, you can perhaps note that Greece is one of the worst backsliding countries in the EU in terms of the speed or the intensity of the backsliding. If you adopt a different departure point, in the case of Greece, essentially, if you look at autocratization in the past 2 years or in the past 3 years, the intensity of the backsliding has been quite phenomenal. In addition to EU member states, perhaps worth mentioning the presence in the top 10 in terms of magnitude of decline of one EU candidate country, Serbia. Now, all of this is important background information, because now I'm going to tell you about the EU's responses or non-responses in respect especially of the countries or EU member states I have mentioned so far. But in fact, I almost forgot about this slide. In addition to the VDEM Democracy Annual Report, I would advise you also, if you're interested in the situation in the EU, to look at the Rule of Law Report 2025 put together by an NGO known as Liberties. And you can see that Hungary is identified as the weakest link, according to this NGO, in terms of non-compliance and rule of law backsliding. But they identify a number of countries I have not mentioned or which have not been picked up by either the World Justice Project or VDEM. Italy, Croatia, Slovakia, and then they identify a number of countries experiencing some rule of law issues, but less in a less systemic manner. And you can see Belgium, France, Germany, Sweden being mentioned. And then there is only one positive example, so to speak, but it is presented as a cautionary tale, the example of Poland, where I was last week. And as you may know, essentially Poland is seen as essentially as a success story to some extent because of the presence of a pro-rule of law government. But in the for different reasons, rule of law restoration efforts have stalled to a large extent. Now, let's have a look at what the EU has done or not done in relation to many of the EU member states I have mentioned. And the situation, if I have to summarize, is that the EU has not been very effective at dealing with democracy and rule of law backsliding, and mostly due to a lack of political willingness to address the issue. What we have seen in the past 10, even 14 years has been the dramatic development of a set of rule of law tools, but these tools have not been used properly or have been used in a too little, too late fashion. There was an exception to my argument. That was essentially an exception which lasted about 18 months. In 22-23, the Commission and the Council were very active in terms of trying to sanction violations of EU rule of law requirements in respect of Hungary and Poland. In the case of Poland, there was a change of government then, which was followed by essentially the EU dropping enforcement action. In respect of Hungary, however, the situation has not improved, but for political reasons, essentially, the EU's Commission and Council have stopped enforcing or using the rule of law tools in a very proactive manner, and now just waiting, essentially, as far as I can see, for the results of the incoming elections in Hungary. There is a pending case worth following or worth paying attention to. What you can see described on the slide as financial appeasement. Essentially, the Commission responded to extortion tactics by the Hungarian government by unlocking access to previously frozen amount of 10.2 billion euros. And they did so on account of judicial reforms, which actually do not change anything in terms of compliance with the rule of law. For the European Parliament, the Commission essentially misled not only other EU institutions, but misled the Parliament itself and the broader public at large, which is why the Parliament took the very rare step of suing the Commission for essentially lying to the Parliament about why the amount of money was unfrozen or unlocked. Regarding the other countries I've mentioned, I think I have mentioned the example of Romania. Romania, as you may remember, was identified as one of the rule of law declining countries by the World Justice Project in 2024. What did we see done by the Commission and the Council? We saw the both rewarding Romania by removing or ending a specific rule of law mechanism which was established at the time of Romanian accession. When it comes to Bulgaria, we've seen the same, essentially, to put it informally. Both the Commission and the Council have looked the other way, and any inconvenient factual development has been ignored, and no enforcement whatsoever has been seen in respect of the rule of law violations one can identify in both Bulgaria and Romania. Situation in other EU member states mentioned by VDEM or the World Justice Project. I think Slovakia was mentioned, or Greece. Slovakia is even more a worrying example of autocratization. Nothing done to this day when it comes to Slovakia, arguably officially for legal reasons, but de facto for political reasons, as there are multiple grounds for actually activating several rule of law mechanisms. I suppose we can discuss the non-legal factors explaining the lack of enforcement at EU level during the Q&A. This, what I have described as a reality denial assessment of rule of law situations, can also characterize rule of law assessment made by the Commission in respect of countries such as Serbia. You could make the same argument in respect of EU reports in relation to Turkey. Essentially, whenever geopolitically required from the point of view of the Commission and the Council, the objective inconvenient rule of law developments are simply going to be ignored for technical reasons. Usually when the reality of the rule of law situation in a specific country is ignored and there is no enforcement, then there is a lack of judicial remedies available to natural and legal persons to object to what is in effect a course of appeasement. What has been the impact of rule of law backsliding in the EU on the case law of the Court of Justice? I think it's not widely known or impactful in a negative way. Rule of law backsliding has been on the caseload of the Court of Justice. This is not my graph. This is a graph I took from a very good article published inter alia by Professor Tommaso Pavone on the rule of law case law of the Court of Justice. And you can see the huge growth in the number of cases lodged before the Court of Justice, raising essentially, in most cases, judicial independence matters at the level of EU member states. So 95% of these new cases concern national measures or practices targeting specific judges or specific courts or the national judiciary in a specific country in its entirety. Not all of these cases are the same. This is from the same article. Long story short, the most widely used avenue or judicial avenue when it comes to upholding the rule of law in the EU has been the mechanism known as the preliminary reference ruling. So this means for the non-EU lawyers listening to this presentation, every national judge in any EU member state can and sometimes must submit questions to the Court of Justice on any issues relating to EU law which is directly necessary to answer in order to solve the dispute pending before the National Court. In the past few years, it was mostly due to Polish judges and Romanian judges that the Court of Justice was given the opportunity to address some of the most outrageous violations of judicial independence I have seen since started working on these issues about 25 years ago. So what does that mean? It means that in 90% of the cases, if not more actually, it's not the commission or the answer or let me backtrack. Most of the rule of law judgments issued by the Court of Justice are issued on the basis of questions submitted to the Court of Justice by national judges. Political institutions have been extremely feeble when it comes to upholding the rule of law, notwithstanding the very strong rhetoric originating from the EU political institutions you can hear on a regular basis. Now let's compare essentially the impact of rule of law backsliding on the Court of Justice to the impact of rule of law backsliding on the Strasbourg Court, the other supranational court in Europe. I'm just going to use the example of Poland, since as far as the EU is concerned, would be arguably the worst case of backsliding, even worse than what happened in Hungary for different reasons. But in terms of the intensity and the systemic nature of the attacks against courts, I would say Poland is in its own league. As you can see, there is the court refers to about 700 applications regarding the rule of law crisis in Poland, only in respect of the alleged breaches of the right to an independent tribunal established by law. To this day, these applications are still pending because there was a change of government in Poland, but for different reasons, mostly because the Polish president has been objecting to rule of law restoration efforts. These pending applications have not been adjudicated yet, and the situation remains almost as bad as before. But it means, as you can see, 700 individual applications. And now let me give you some numbers regarding the same country in terms of EU applications. So just to focus on the situation in Poland, I've just told you about 700 applications. This slide is a bit out of date, sorry, I didn't have time to update it ahead of today's presentation. But the same overall proportion or allocation will be still correct today. The Commission, in the case of Poland, has issued, has launched, or has brought before the Court of Justice 5 infringement actions. To this day, the Court of Justice has received more than 50, close to 55 preliminary ruling requests regarding judicial independence matters in Poland from Polish judges. Now, if you compare the overall number of EU cases to the overall number of individual applications, you can see obviously that we're talking about 60 EU cases versus 700 individual applications. And this is only for one country as far as the Strasbourg Court is concerned. The situation if you look beyond the EU, then the Strasbourg Court has to deal with even more applications when it comes to countries like Hungary, and before he left or was de facto expelled, Russia. So when it comes to case law, what we have seen in the past few years is a dramatic growth or dramatic increase in the number of pending applications raising structural rule of law matters before both the Court of Justice and the Strasbourg Court. Here, I would like to make an additional point, which is that a lot of these new cases pending before both the Court of Justice and the European Court of Human Rights concern judges, individual judges or individual prosecutors, and some cases, individual lawyers who have been targeted by autocratizing authorities. The case law, therefore, has developed in order to actually help what I have described as applicant judges and prosecutors and lawyers. So here we're not talking about judges adjudicating cases, but judges as target of autocratizing countries. Same applies for prosecutors. Most of the case law from the Court of Justice has to do with national measures targeting judges for different measures. Petra has mentioned a couple of them. Early retirement, retroactive change to the retirement age is a classic, but also arbitrary disciplinary measures, arbitrary transfers. And in the worst case, you have state-sponsored campaign of hatred towards judges, resulting in death threats targeting judges or prosecutors. In the case of Turkey, he went as far as prison time, torture, and so on and so forth. So the situation is quite bleak. The case law has dramatically developed, so much so that essentially I was asked to publish a guide to help judges when they are themselves the victim of autocratizing country. And you can find this guide online. Now, looking beyond the case law, I wanted to finish on the growing and new rule of law issue, which is particularly worrying. What we're seeing in the EU, that's maybe not new if you have experienced rule of law backsliding beyond the EU, but this is quite new in the EU context. What we're seeing is an increasing number of EU member states, or an increasing number of authorities in an increasing number of member states openly violating EU law, is not simply in the field of rule of law related fields, but across the board. So this is what the Parliament has described as the sometimes open and unashamed non-compliance with EU law in various fields. In this resolution of February 2024, the Parliament has also criticized quite strongly and rightly, in my view, the Commission and the Council for failing to actually enforce EU law when EU law is violated in a systemic way by the national authorities of several member states. A new aspect of this unashamed non-compliance with EU law is that you have unashamed non-compliance with judgments of the Court of Justice. So this is quite new, this is growing in importance, and this is why I just wanted to highlight this issue. Non-compliance with judgments of the Court of Justice is, however, nothing new from the point of view of the Council of Europe. This is a map also about non-compliance with judgments, but non-compliance with leading judgments of the European Court of Human Rights. As you can imagine, red is not a positive color to be used. So essentially, this is a map of non-compliance with Strasbourg Court judgments only as far as the EU is concerned. If we were to look beyond EU member states of the Council of Europe, there'd be a lot more countries in red. So what we are facing today is increasing open, defiant, unashamed non-compliance with judgments of both the European Court of Justice and the European Court of Human Rights. What has been the answer of the Commission? Actually, not much. What we have seen is that non-compliance data, when it comes to the Strasbourg Court, is included in the Commission's annual Rule of Law report, the latest edition of which is going to be published tomorrow. So tomorrow you'll see that the Commission is going to release country reports for the 27 member states, and you will find non-compliance data in respect of the judgments of the Strasbourg Court for a number of reasons. But paradoxically, these EU country rule of law reports do not include clear data on non-compliance with judgments of the Court of Justice of the EU. So you have the paradoxical situation where you have EU reports discussing non-compliance with non-EU judgments, whereas the EU judgments, when they are violated, are not the subject of comprehensive developments. The reason is, as far as I can see, that the Commission does not want to state explicitly when a member state is not complying with a judgment of the Court of Justice, because if he were to do that, then he would have a legal obligation to justify its position if he were to fail to actually bring the situation of non-compliance before the Court of Justice of the EU. So to preserve its discretion not to actually sanction a member state for non-compliance with ECJ judgments, they're just essentially sitting on the data, something I would be strongly critical of course. Now, just my last slide, because this is a judgment which is worth highlighting. In this case, actually, the Commission did the right thing. And this is a rare case where the Commission at last did do something in terms of open, unashamed non-compliance with previous judgments of the Court of Justice. This is an infringement action. Long story short, in the EU system, the Commission can bring infringement action against any violation of EU law against any EU member state. Then the infringement action can lead to a judgment of the Court of Justice. And if the Court of Justice judgment is not complied with, then the Commission can return to the Court of Justice and can ask for financial sanctions. And normally, the Commission would ask for both the payment of a lump sum and a penalty payment until compliance. This is the leading case now when it comes to financial sanctions for non-compliance with a judgment, which is of a serious and sustained and deliberate nature. What is worth noting in this case that the Court of Justice, essentially to simplify, multiply by more than 100 the amount of the lump sum and the penalty payment he wanted the court to order to punish or sanction Hungary for deliberately violating or not refusing to comply with a judgment of the Court of Justice. Since then, the Hungarian government has refused to pay both the lump sum and the fine, but it doesn't matter because the amounts can be directly deducted by the Commission from EU funds already pre-allocated to Hungary. Petra did mention the latest mumbo-jumbo type of litigation the Hungarian government wants to initiate. I'm not sure whether they have actually moved forward with this. But this is not surprising. Essentially, in the case of Hungary, you're dealing with a system which relies on lawlessness as their default structure. This is a regime which does not want to be subject to any sort of constraints, either legal or political or even social. And obviously, they have no intention of complying with any judgment, let it be domestic, European, or international. But it is not because you have non-compliance with a judgment that you should stop enforcing the law. You should just adjust the way you are enforcing the law in order to guarantee compliance. This is an existential issue. You cannot have a common legal order where essentially a member state can stop being democracy and can also just comply with their legal obligation in an a la carte fashion. So thank you very much, and happy to answer questions during the Q&A.
Thank you very much, Professor Pesch, for this, as you called it, dire view on Europe. After the second presentation, we are remarkably behind our schedule, but I don't want to cut Professor Satterthwaite, so I will cut at the end. We will have to shorten our discussion. With this, I give you the floor, Professor Satterthwaite. Take your time.
Thank you very much. And actually, I will shorten my remarks in part because many of the things I would have said have been said already, which I think is a good sign that we have some confluence of analysis. So just a brief discussion about where my remarks are coming from. So as has been explained, I am currently serving as the UN Special Rapporteur on the independence of judges and lawyers. And this is just briefly for those of you who aren't as familiar perhaps with the UN human rights system. This is an independent role. I'm appointed by the Human Rights Council to serve this role, and I serve the role on an independent and voluntary basis. So anyone who's a special rapporteur in this way is not a UN employee, but we are appointed by the UN. And the point is that we play an independent role, and we report back to the Human Rights Council on trends under our mandate. And we also report to the General Assembly. And so what I'll be talking about today is some analysis that I undertook looking at the issue of autocratization. And I will be using the term autocratization in particular, as already explained and introduced by Professor Pesch. It's a term that allows you to talk about the move toward autocracy from any starting point on the spectrum. So if you think about the spectrum from liberal democracy over to autocracy, any government can move in one or the other direction. And so I'll be talking about autocratization as a trend that can start anywhere. And I think it's very helpful and important to do that when you're looking globally at the situation, because countries really do start in this process many places along the spectrum. So I want to tell you about a typology of types of autocratizing attacks on independent court system that I have developed through the work that I do as special rapporteur. And just briefly, where does my information come from? Let me tell you about that. So I get individual cases or submissions to me from judges, from lawyers, from prosecutors who are suffering the kinds of attacks that we've already started to discuss. People will write to me saying, my independence is being undermined, or I'm being attacked as an independent judicial operator. And then it is my job to bring these allegations to the attention of the relevant government. And my analysis of these cases is under international human rights law. So particularly, I look at the International Covenant on Civil and Political Rights, which does protect the right to access an independent and impartial court established by law, and also the right to fair trial, which requires access to not only a lawyer of one's choice, but then a variety of procedural protections, including an independent court. So that's really this place where I get most of my information. I also undertake in-depth country visits at the request of governments. Unfortunately, because of the liquidity crisis at the UN, I've only been able to do one of those visits this year and one last year, but I did 2 the year before. And so those always give me a lot more in-depth information. And then I write thematic reports, which are reports on these kinds of trends that I'm looking at across the world. So I'm going to skip a lot of my introductory remarks because many of the things I would have mentioned have already been discussed. And specifically, those would be about this trend of rule of law deterioration, which is not only one that affects the European region, which has been discussed already, but it's really impacting the whole world. And you saw Professor Pesch's slides that gave you a snapshot of some of those key places where we're seeing autocratization and decline of democratic institutionalization and democratic norms. And so what I want to talk about now is the use of a variety of strategies by autocratizing governments to attack the independence of courts and judges. And so this is a dynamic that you see in places where autocratization is increasing, and many places you have a lot of dynamics that are very similar culturally, politically, but I'm going to be focusing on the dynamics attacking independent courts. So I have essentially constructed a typology of attacks. And in this work, I've seen these kind of what we might call strong leaders. So when I'm saying strong leaders, I mean leaders that are using a certain discourse of power to portray themselves as especially strong and capable. They often use a populist discourse, which I imagine we'll also discuss during the Q&A. And these strong leaders have tended to use this 4 different kinds of attacks. I want to start out by saying that it's difficult sometimes to think about how to divide legitimate judicial reform from attacks or changes that are illegitimate. And I think one way to sort of talk about how to distinguish those is to say that it's important to look at whether reforms of judicial systems allow those systems to retain their independence and their impartiality, or do they increase the role of the political branches? So the executive, the legislature, are those branches increased both in their capacity to change the independent judicial system, and are they changing the judicial system to make it more possible to influence those independent actors with political views, with political imperatives, or with political affiliation? And if so, I would call those autocratizing moves. So let me move on to the 4 categories. So the first strategy or category of attack is, of course, capturing. And this has been a term that has been used throughout this entire discussion. Capturing involves increasing the executive or legislative control over courts, over judges, over bar associations that have the effect of politicizing those judicial institutions or judicial decisions. A common manifestation of this is rule changes that give greater political control over how judges or members of appointment bodies, such as judicial councils, are appointed or replaced. Or sometimes, as we've already discussed, there is the creation by those political bodies of new judicial vacancies or judicial council vacancies, which allows for new appointments. This can be achieved in a lot of different ways. It has included expanding the size or number of courts, removing existing judges, or establishing or revising compulsory retirement ages. And this famous example of Hungary is a really paradigmatic one, where mandatory retirement age was lowered, which forced this mass retirement of judges, including most of the judicial leadership, of course, who had served for long periods. Similarly, and outside of the European context, in 2024, the Peruvian Congress removed multiple members of the National Board of Justice, which has functioned essentially as a judicial council, in an effort to change its composition. In a dramatic fashion, we also see this happening in Mexico, where a sweeping judicial reform was put in place that is now replacing all sitting judges with judges elected by the general public. About 50% of these judges have just been elected in June of this year, in an election that was marked by incredibly low voter turnout and very high voter confusion. The other half of the judges in the country of Mexico will be elected in 2027. And we can talk about that in the Q&A. Another manifestation of capture is the passage of laws that give the political branches the power to select judges to hear certain politically sensitive cases, such as those involving counterterrorism or national security. In Poland, for example, an extraordinary control and public affairs chamber of the Supreme Court was created, with exclusive jurisdiction over electoral disputes, election results, and complaints and questions of law concerning the lack of independence of a court or a judge. In Hong Kong, very famously, the chief executive was recently given responsibility for designating a specific list of judges who can hear national security cases. And as you will know, national security cases includes cases against democracy advocates and human rights lawyers. So this is capture, and capture, I think, is one of the most commonly understood forms of autocratizing attacks on independent justice, because it's about taking those independent systems over, placing loyalists in them, and thereby capturing the courts and the institution itself. So the second category is curbing. This kind of attack is, instead of usurping control of the judicial system, it's a way of reducing the judiciary's overall power and capacity, and especially its power to check the political branches in their efforts to use their power. This could take the form of, for example, removing or restricting courts' jurisdiction to review legislation or executive acts, or mandating less stringent standards of review or powers of remediation, for example, over executive actions, or limiting judicial oversight in certain politically sensitive types of cases, again, like those involving terrorism or, and this is relevant in my part of the world, or cases involving immigration. In Hungary, for example, constitutional amendments passed in 2013 expressly prohibited the court from reviewing the content of the amendments, as has already been discussed. In the UK, you might recall legislation introduced following a Supreme Court decision aimed at curbing the court's ability to apply and interpret principles of domestic and international human rights law in the asylum context. And in Sri Lanka, the 20th Amendment to the Constitution in 2020 had the impact of centralizing power in the presidency and weakening the judiciary's oversight role. Curbing efforts can also take the form of significant resource reductions or workload increases without concomitant increases in resources. This occurred, for example, again in Mexico before the reforms in 2023, when there was a reduction in the judiciary's resources by the political bodies. And in El Salvador, the justice system has experienced huge workload increases from the mass criminal prosecutions that you may have heard about, but no corresponding increases in staffing or other resources. These strategies create the risk that courts won't have the capacity or sometimes the authority to uphold the rule of law and enforce human rights, especially against the state. Now, those first two categories and strategies are often used against courts, as has been discussed, but they're also used in relation to other legal institutions, such as the Bar Association. So bar associations are really crucial because they help protect and ensure the autonomy and the independence of the profession of the lawyer, which is an important counterbalance to autocratizing governments. Bar associations have often been targeted. This threatens their critical role in regulating the conduct and licensing of lawyers, which enables lawyers to safely advance claims against the state without interference or intimidation. In Afghanistan, the Taliban moved quickly after retaking power to disband the Independent Bar Association and reconstitute an entirely new one under the control of the Ministry of Justice. In Turkey, the efficacy of bar associations have been reduced by legislation that has authorized the creation of competing bar associations with the power to license lawyers. This has resulted in previously disbarred lawyers being able to regain their access to the bar via a different association. And here in the United States, the Trump administration has gone directly after independent bar associations like the American Bar Association, as well as specific individual law firms through executive orders that aim to directly limit their ability to function by removing their security clearances or even barring them from federal buildings, which of course includes federal courthouses. So, as I mentioned before, the third and fourth types of attacks on judicial independence are going to target justice actors. The first two attack and target justice institutions, and the last two are going to target justice actors. So the first of those is instrumentalization. So instrumentalization occurs when political actors misuse existing legal institutions, procedures, and laws to exert undue political influence over independent judicial actors. In these situations, criminal prosecution or administrative discipline may be used in a formally correct way, but with the underlying political purpose to punish or intimidate judges, prosecutors, or lawyers who may hold state officers to account, or who are perceived to be associated with opposition figures or pro-democracy ideals. I've received reports of judges being investigated, disciplined, or even prosecuted after objecting to legislative amendments, imposing convictions in political corruption cases, or challenging corruption in international courts. For example, judges in Uganda and Lebanon have reportedly been disciplined in apparent reprisal for their opinions in high-profile electoral cases and for criticizing the functioning of the judiciary. In the United States, immediately following the inauguration of Donald J. Trump, this time, a wave of removals and reassignments swept through the prosecution service inside the Department of Justice. Those who had been involved in investigating crimes associated with the January 6th attack on the US Capitol were immediately punished by either being removed from their position or being transferred to unsatisfying and often much lower ranked kinds of positions than they had before. In Guatemala, judges and prosecutors have been charged with crimes and placed into lengthy pre-trial detention for work they did to advance human rights and anti-corruption cases. The situation is so dire in Guatemala that several dozen, probably around 50 or 60 to date, judges and prosecutors are in exile, either following criminalization or because they credibly fear it. Members of the judiciary may face disciplinary action for attempting to preserve judicial independence. As we've already heard about, this has happened in Poland, where judges have been disciplined simply for examining complaints concerning the lack of independence and impartiality of a tribunal or judge. And sometimes this occurs en masse. The example of Turkey is unfortunately paradigmatic here, where thousands of judges and prosecutors were arrested and dismissed in the years after the attempted coup. Those arrested included a judge of the UN Criminal Tribunal's mechanism who was indicted, convicted, and imprisoned despite his entitlement to diplomatic immunity. An even more subtle form of instrumentalization occurs when the conditions of service for justice actors are manipulated for political reasons. And this occurs, for example, when states remove security protections for judges hearing high-profile or politically sensitive cases, or when judges or prosecutors are transferred to locations perceived as undesirable or even dangerous. And here, there's an example of a Colombian prosecutor who was notified shortly after lodging key accusations in a case concerning well-connected individuals that she would be transferred to another jurisdiction where she faced security threats. Similarly, the issue of security protection is now under discussion in the United States, where judges are considering whether they should make the Marshal Service, which is their protection, reportable directly to the judiciary. Right now, those Marshal Services are under the executive branch. And so the judges are looking at whether that could potentially pose a problem down the road. So the final category I want to talk about is even more drastic situations where the government employs patently unlawful and abusive methods to curb the work of justice actors. This is the fourth and final strategy, which I'm going to call weaponization. This is an extreme form of attack on independent justice operators in which these facially unlawful acts like arbitrary detention, torture, enforced disappearance, physical attack, and even assassination is used to shut down the work of independent justice actors. Of course, it should go without saying that legal personnel should be able to carry out their duties without fear or for their family's safety or for their own physical safety or freedom. But it is said in international norms, and this makes clear that states are obligated to provide the protection necessary to keep judges and their families safe. But in a concerning number of instances, states are not only failing to protect justice personnel, but themselves attacking those personnel. In its most mild form, this takes the form of public disparagement and labeling of justice actors by executive or legislative officers. Now, vigorous disagreement is a cornerstone of the judicial process and, of course, is a mark of democratic discourse, and critiques of reasoning, disagreement with a decision, or even expressions of dismay concerning a case outcome by any official of the government is perfectly appropriate. But when government officials go beyond this by launching ad hominem attacks that disparage personal characteristics or identities, describe justice workers using degrading or humiliating language, or label them as enemies of the state or individuals who are trying to destroy our culture or other kinds of things like this, these kinds of comments cross the line. And especially when they're repeated and lack foundation, they really do suggest calculated attempts to intimidate and influence judges. I will give the example of Mexico, where the former president, before the judicial reform, used his daily press conference to single out, label, and denigrate named judges who had ruled against the government. This labeling was often then followed up by formal disciplinary complaints and online harassment. In the United States, the president, the vice president, and their allies have denigrated specific judges who have ruled against executive actions. In a chilling demonstration of cross-border anti-democratic solidarity, former Trump advisor Elon Musk reposted a social media post from President Bukele of El Salvador, in which he encouraged the US president to follow his lead by removing judges who sought to block his initiatives. But sometimes governments don't stop at words. In addition to these reported instances of harassment and threats, judges and prosecutors have been arbitrarily detained and sometimes subjected to temporary disappearance when their actions displeased other branches of state. Judges and lawyers have often been subject to torture, to cruel and degrading treatment, and even to assault or killing in circumstances that have been inadequately investigated. For example, in Guinea-Bissau, lawyer Marcelino Intupe was subjected to violence and attacks after being appointed to represent various defendants accused of participating in a coup attempt. In the Philippines, human rights lawyer Juan Macabad was killed, and human rights lawyer Angelo Carlo Guillen survived a vicious attempt on his life. In Eswatini, which I recently visited, lawyer and pro-democracy advocate Talani Maseko was assassinated in his home in front of his family, only weeks after another lawyer survived such an attempt. These flagrant and obviously unlawful actions are unconscionable, but they're a direct threat and attack on judicial independence. When judges and lawyers feel that their personal safety is at risk as a result of their professional activities, they can hardly be expected to objectively assess state actions. And yet this is their essential role in a functioning legal system. Each of the 4 generalized types of attacks I've described threaten this key role. The 4 categories of attacks on judicial independence share a common deep discomfort by strong leaders to abide constitutional checks as interpreted by the judiciary concerning executive or legislative power. They also demonstrate a conviction that judges and prosecutors are somehow in opposition to the will of the people as embodied in the strong leader. The public-facing rhetoric used by such leaders and political actors to lay the groundwork for sweeping changes often deploys an implicit critique, of the supposedly non-democratic nature of the judiciary. And here, I think it would be really interesting for us, perhaps during the discussion, to talk about that larger discourse that figures judges, lawyers, prosecutors as some kind of anti-democratic force that then becomes the subject of attack. And I will stop here since I think we do want to save time for conversation. And again, thank you for the opportunity to talk with you today.
Thank you very much, Professor Satterthwaite. Yeah, you have mentioned a few times the question and answer time, but we are really short in time. And you have mentioned a lot of details already. So I'd first like to make anyhow some conceptual clarification. What are we really talking about? Professor Bard, when we talk about backsliding democracies, what exactly are we referring to? How is this different from autocratic regimes? And do you think this distinction is not important for legal and political analysis, or should we make it?
Oh, shall I respond immediately? Okay.
Yes, please.
Yes, of course. When I refer to backsliding regimes, I refer indeed to autocratization. And this is a huge debate, mainly in political science, whether we can call these regimes autocratic regimes, because they are no fully fledged dictatorship, we know that, but they are not democracies either. Professor Pesch has already shown that they are not even free countries. I'm not sure whether, Laurent, you mentioned Freedom House, clustering Hungary, for example, among the non-free countries cluster. Now, all these differentiations between autocratic regimes, hybrid regimes, something in between, they do they didn't make a difference, frankly, in my presentation. These are more there for political theory, and I think there might be important distinctions. For me, it only matters that destruction of checks and balances via legal means, everything having a veneer of legality, is the characteristic of these regimes. We might also call them illiberal regimes only because they call them illiberal democracies, even though some scholars point out the fact that this is a contradiction in terms. Either you have a liberal democracy or you don't. There is no such a thing as a liberal democracy. I deliberately didn't want to go down that road and enter into this political science debate when talking about the consequences of backsliding for the European project. And what I particularly like, if you are talking about terminology, is front sliding. So we tend to talk about rule of law restoration at times, or transition 2.0. I particularly like the term front sliding that has been introduced in a recent article by Christoph Illy and Tommaso Pavone, who has already been mentioned, and Antoinette Schertz. I think this article is not yet published, but these authors make the point, and just remember that two of them are non-lawyers again in this debate, that front sliding doesn't happen just like traditional transition to it. So there is no revolution behind it, there is no significant moment, there is no constitutional moment. Front sliding after a period of illiberalism or a period of hybrid regime happens in a very how shall I say, it has its challenges from a legal perspective, typically because after a period of autocracy, there are pockets of power which try to prevent front sliding, or which try to prevent transition 2.0. So this is not like 1989 or 1990, but there will be pockets of power in government, the prosecutor services, the Supreme Court, the Constitutional Court, and so on, which are trying to prevent it. And this is the challenge for us lawyers, how to do that without
sorry, we have
to do translating.
We have to keep it short.
Exactly. So that's my point. To make this very short, for my presentation this time, it didn't matter what terminology we use.
I'd like to stay with this term front sliding and ask Professor Pesch. Front sliding means going towards liberal democracy without the due process to do this. Do you agree? And is this correct? We can't hear you. You're muted.
Front sliding is a new concept. No, essentially, the short answer is when it comes to restoring the rule of law, you want to do this in a rule of law compliant way.
Okay.
And you can
That's
do
important.
that. Yes, it goes without saying. My only issue with whenever we're talking about restoring the rule of law in the EU or in Poland, especially, the key issue from my point of view is actually whether we need to attach any legally binding consequences to illegal measures to begin with. So first, you have to assess and agree on the legal impact of illegal measures and practices. And it's not always that straightforward. Let me give you a concrete example, which is actually a big headache. When a national judge has been illegally appointed by an unconstitutional body, what should you do? Should you consider this appointment to be defective from day one, and meaning that essentially the judge was never a judge to begin with? Or do we actually give these defectively appointed judges a chance to actually remedy the illegal nature of his appointment? You have different schools of thought on this. Okay. Another issue is, what do you do with a judgment which has been issued by what is in effect a non-court? let's talk about the judgment of the Constitutional Tribunal of Poland. What do? The Court of Justice is about to decide a case, a very important case, in which the Court of Justice might rule that the Constitutional Tribunal, for a number of reasons, ceased to be a court for a few years. So my question to you, Thomas, would be, what would you do if you are dealing with a court which is in fact not a court because of defective appointments? And then what do you do with the judgments issued in the meantime? These are questions which are not easy to address, but I'm less preoccupied with rule of law restoration efforts personally at this stage, because backsliding is still very much the flavor of the day. It's getting worse, whether you call it backsliding or authorization. The bottom line is we are facing an existential threat if you believe in democracy and the rule of law and respect for human rights. Essentially, we're not talking about the usual routine legal issues of whether you have maybe exceeded the legal basis. We're talking here about macro constitutional issues. We're talking about essentially a return to the 1930s. We're talking about abuse of power as a default setting in a legal system. So these are the kind of questions I'm worrying about. I don't have time to actually think about front sliding. I would love to, but there's so much actually to be worried about when it comes to backsliding.
Yeah, these are the same questions I'm worried about. But let me stay on this topic just a moment longer. Professor Barr presented 5 steps of the autocrat's playbook. And Professor Satterthwaite, you were offering a 4-part typology of the tactical strategies: capturing, curbing, instrumentalizing, and weaponizing. Could we not cool a little bit down and say only when one or more of these strategies are used, we have a real problem? Professor Satterthwaite.
I think that might be true in the sense that I cannot at this moment think of a case where only one is used. I mean, they tend to really occur together. Professor Bard explained that there's a chronology to it. I think that that's likely true, but I also have seen many of them happening at the same time. I think that there's a reason for that. If you take the example of attacking and denigrating judges as, elite anti-democratic actors, that really does pave the way for an autocratizing leader to take some very key steps to dismantle those institutions. So I would not want to say that these things independently are not a problem, because, and certainly in my position, I think it's very important that we call them out independently and individually as they're happening, and that
my question is more, we have now lists of backsliding democracies, and I'm not sure that in all these backsliding democracies we have really those problems, these criteria you mentioned. Shouldn't we take it a little bit cooler and really talk about the cases where there is a problem?
So I would say, from my perspective, each of the cases that I've mentioned and each of the type of attacks are actually in and of themselves problems as a human rights matter. So they're problems because they are attempts to dismantle independent and impartial courts established by law, and to harm the independence of justice actors. And so I think independently, those things all do need to be addressed. It may be the case that in not every single instance is there a larger dynamic of backsliding. That may be the case, certainly. But individually, I think any of these acts are problematic and should be called out and should be stopped.
Okay, so let's take this away, leave this away, and go to the European and international responses. Professor Barr, the case of Osman Kavala, despite the clear ruling by the European Court of Human Rights in December 2019, continues unresolved. Turkey has ignored the judgment and the infringement procedure. Kavala remains imprisoned up to today. What does this say about the Council of Europe's capacity and willingness to enforce legal decisions?
I believe that the Council of Europe system is a very soft system. So it very much depends on the gentleman's agreement, kind of, the high contracting parties. If a judgment is not implemented or it's not enforced, then of course the case goes to the Committee of Ministers, and then the case ultimately can go back to the European Court of Human Rights, and then it can determine that the original judgment hasn't been enforced. But what eventually happens is that the case goes round and round. So this is part of the reason why initially in the 50s, 60s, the court was very deferential. So as to gain legitimacy, and only when it gained legitimacy and it was an entity that couldn't be avoided, did it dare to go one step further than just requiring just compensation in individual cases and show to systemic problems, for example, via the pilot judgment mechanism. But we see, unfortunately, not only in Turkey, but also in other jurisdictions. The UK is, of course, a prime example, but we see in other jurisdictions, including my jurisdiction, Hungary, more and more cases where judgments are simply being disregarded. And I think this is very regrettable, because other countries might just follow suit, seeing that there are no really efficient and dissuasive mechanisms to enforce these judgments. So the whole thing might collapse as a house of cards if this trend continues. And I'm exaggerating a little bit, but I think I share the concern of the judges that Laurent had on his slides, that the situation is very, very dear indeed.
Okay, you address Professor Pescia. You said that the EU was not very effective with its rule of law promotion measures. And is it a lack of political will, or what's the problem, and what can be done?
So obviously, that's my personal view, but let's just say that having kind of pay attention to this issue for a long time, the argument for a long time has been that the EU was lacking a proper toolbox. So the EU was able to identify clearly the problem 15 years ago. So
that's doubtful, huh?
Yes, so the expression was used, rule of law crisis. So then it was clearly that something was wrong, something new was unfolding in the EU. But instead of dealing with it on the basis of the existing toolbox, the diagnosis was, this is a new problem, but we lack the tools to address the problem. And then we wasted, if you pardon my French, about 10 years looking for new tools. In the meantime, the problem got worse and worse. So much so that now non-compliance with domestic and European judgments is growing by the day. Now, there has been a bit of enforcement, at least in the case of Poland. You can argue that the Commission did react quickly, or at least more quickly than it did in the case of Hungary. But overall, the key problem is political in nature. We have two key institutions, the Commission and the Council. They both treat compliance with the rule of law or enforcement of the rule of law as a political question. And they're going to be very strict enforcers of the rule of law when this is the path of least resistance. So when the easiest way to deal with the problem is to enforce the law will be enforced. If it's a difficult path ahead and they have short-term partisan or geopolitical considerations, then the rule of law is going to be used as a variable of adjustment, so to speak. Essentially, what we've seen is political expediency prevailing over strict, consistent enforcement. So bottom line, we don't like the tools. What we like is a political leadership when it comes to rule of law regulation. So we have all the legal tools we need, but those in charge of the legal tools are political actors. As far as the Court of Justice and the European Court of Human Rights are concerned, as far as the EU, they've done, I would say, the best job they could do in the constellation they found themselves in. I don't always agree with, I find some judgment maybe too timid. Some people may find them too expensive, but I would say both courts have done the best job they could do in a difficult environment at the end of the day, in the EU system at the very least. If the Commission and the Council do not act, then there's very little you can do. As a matter of fact, in my part-time role as a member of a CEU Rule of Law Clinic, I kind of lead some strategic litigation efforts, and we have brought some legal actions against the EU when the EU itself was arguably not upholding rule of law requirements. But we face legal standing issues. So in the EU system, actually, if the rule of law is not enforced by the EU institutions, natural and legal persons, including association of judges, have a very little effective legal avenues available to them. It's even worse in the ECHR framework. I mean, you were mentioning Turkey. Essentially, I think as far as Turkey is concerned, we have run out of the legal options. At this point, I would say this is a membership issue. So at some point, if a member is structurally, systematically, proactively violating the values on which the organization is based, then this becomes essentially a membership issue, no longer an enforcement issue. And the same point has been made actually in respect of Hungary, with some, not my viewpoint, but essentially some have argued that the Hungarian authorities have gone so far in their non-compliance that they have de facto withdrawn from the EU, and that in fact the time has come to exit them from the EU system. I don't think this is very realistic, but the fact that we are discussing these issues show like how bad the situation is compared to where we found ourselves in 20 years ago when we were at the start of this so-called rule of law crisis.
Thank you. So to bring it to the point, we're waiting for political leadership and crossing our fingers. So it's Friday evening, and I don't want to stretch the patience of the viewers. So therefore, I already go to a last round, and I wanted to ask each of you if you could offer just one very short piece of advice to lawyers or judges or civil society actors working in countries currently facing backsliding problems. What would this advice be? So you can't say we are waiting for political leadership. That doesn't help them. So who wants to begin? Professor Satterthwaite?
Sure. So I think my piece of advice would be that those of us impacted by this crisis, and I think that really is almost everyone in the world, should recognize that the independence of the judiciary is not only something that concerns the judiciary, but it concerns all of us. And we need to act to protect it as early as possible. We need to be vociferous in that. We need to talk about why independent justice matters to everyone, that it's a protection for the most vulnerable, it's a protection for equality, it's a protection for access to justice. And we need to speak out when we see it under attack. So I would call for an international solidarity on this account, and for real bravery in standing up and speaking out to protect the rule of law.
Thank you very much. Professor Pesch, what would you add?
I would completely agree with the emphasis Margaret put on transnational solidarity. All legal professionals on this goal, we are going to be, if you are not targeted by would-be autocrats, you might well be targeted at some point. We need to get together. The autocratic playbook is more or less the same regardless of jurisdiction. So we may as well get ready ahead of time. I would say if you are in a legal system which is yet to be subject to a kind of a autocratization process, my advice is to stress test your legal system. Identify the weak spots which can be used, misused, abused in your legal system by a would-be autocrat. So let's say, think of the situation where you have an Orban elected in your country. How long would it take to transform your legal system into a de facto electoral autocracy? So essentially, I would say you have to focus on this, the resilience of your legal system ahead of stormy weather. And in the short term, however, when it comes to rule of law issue beyond one's jurisdiction, you have to make it legally and politically costly when it comes to those undermining the rule of law. From an EU point of view, I would say you should not undermine the value of litigation, even when you're going to ultimately potentially lose your strategic litigation. And at the same time, you should not give up on the political avenue. What Polish judges have done actually when faced with an onslaught of authoritarian measures actually is the model to follow. Solidarity within, solidarity outside, quick translation of every piece of measure targeting them, political lobbying in the parliament in Brussels, political lobbying in Strasbourg, involvement of foreign academics, and all of this mixed with strategic litigation, bringing cases as quickly as possible to both the Court of Justice and the Strasbourg Court. That would be my cocktail, my advice in terms of the cocktail of measures and actions in the short term and the long term.
Thank you very much. Before I give the word to Professor Barth, just one remark. Wim Woermans presented in our first podcast the system of the Netherlands, a multi-party system. And this multi-party system we have also in Switzerland. And I think this is a very good safeguard against autocratic tendencies. And maybe we should make some promotion for this system some more. But with this remark, I hand over to Professor Barth.
I actually take up on what you just said. So I think we should make use of supranational, including European institutions. For example, when it comes to front sliding, of course, it is not happening without due process. We should make use of what the Venice Commission is saying, what the European Union institutions are saying in terms of what is judicial independence, what does it entail, what does it not entail. The European Court of Human Rights is a very helpful player in saying, for example, in an Icelandic case, that irregularly appointed judges can be removed, and it's also an obligation to have them removed. So just point to make use of these European instruments. I think it's also a good idea for lawyers to engage in strategic litigation, make use of the available channels, push your courts to ask questions in the form of preliminary references. And of course to NGOs, but I think Professor Satterthwaite already said it, explain it that judicial independence is not the privilege of judges. This is a right of all of us, and podcasts and discussions like this one actually help making this, to make this understand. Also for academics, I have two suggestions. The one is to abandon a false solidarity. So let's distinguish genuine legal theories and ones that are just serving political aims, and let's not pretend to be able to conduct a meaningful dialogue with academics that do not speak the language of constitutional democracy. Many things that we are discussing only work in the framework of constitutional democracy. If we step outside, then certain legal constructs, theories simply do not work. And finally, I think given the immense attack against academics in Turkey, in Poland, in Hungary, in other countries, I think transnational solidarity for academics, it really makes a difference. Thank you very much.
Thank you, all of you three. This was a very refreshing discussion. It was very short, so much too short. We didn't have enough time. I would have had a lot of more questions to you to discuss. Your insights have provided many new perspectives, and the discussion with you has been very enriching. And we only scratched the surface of many important questions, and it's still a lot more to discuss. We intend with our project to continue the discussion in upcoming events. And ladies and gentlemen, subscribe to the newsletter on our website, backslidingdemocracies.org, and then you can stay informed about the upcoming events. And I want to thank all of you for being with us today. We are hoping to see you soon again, and have a good weekend.